All right, well, welcome everybody. My name is Ben Fink. For those who don't know me, I'm one of the shareholders here at Berman Fink Van Horn. Really appreciate everybody coming today. It seems like this topic has drawn a lot of interest, and so we're real excited about the turnout. My colleagues Neal Weinrich and Carson Madral will be speaking with me, and we'll be talking about the future of non-competes in the wake of the proposed FTC ban. So we'll talk about a few things. First is how we got here. The other is what does the FTC's proposed rule do? What does it say? What is it going to mean? What's the current status of the rule, because it is not yet in effect? What's the likelihood that what they've proposed actually will get implemented? And then most importantly, what employers should do now while this process is playing out. So I want to talk a little bit about how we got here, because I think it's really important to understand the history and the context and why the FTC has chosen now to propose banning non-competes nationwide, sort of period, full stop, not any, very few exceptions. And it's really sort of a somewhat surprising development, especially for those of us who have been really watching this process play out over the last 5 to 7 years. So a lot of this can be traced back to Jimmy John's. For those who don't recall seeing this in the news, it was all over sort of the mainstream news when this came out. But Jimmy John's, back in prior to 2014, if you went to go work for Jimmy John's, even if you were just going to be making sandwiches, you were required to sign a non-compete agreement that said that you would not basically work for any other sandwich shop within 3 miles of any location of any Jimmy John's anywhere in the country. So, you know, your kid is in, college in Athens and works at a Jimmy John's, and then decides to take a job and move to New York, and maybe decides to work for Panera in New York, and it's within 3 miles of a Jimmy John's. In theory, Jimmy John's could say that your kid was violating their non-compete by doing that. Hopefully, the absurdity of that is not lost on everyone, and that's really one of the first times where there was a high-profile situation that sort of got out in the news, and there was a lot of hand-wringing and consternation about companies like Jimmy John's imposing non-competes, especially on folks who are making sandwiches as opposed to high-level executives or folks who have access to trade secrets and that kind of thing. So Jimmy John's, there were a number of state enforcement actions. One was brought by the New York Attorney General. I think the Illinois Attorney General also looked into it. And ultimately a settlement was reached in which Jimmy John's agreed to a whole bunch of things, including no longer requiring folks to sign these kinds of agreements. And so that is not the start of the process, but that was really what, in my view, sort of turned this into a more mainstream issue that folks in government and folks in politics became interested in. And I've been telling clients for years and years and years that when industry engages in some abuse, that's when the government gets involved, right? And I think this is a classic example of that, where many companies, Jimmy John's is not alone, many companies were using and abusing non-competes really for anti-competitive purposes, as opposed to trying to protect legitimate business interests like customer relationships, employee relationships, confidential information and trade secrets and things of that nature. And so, I think that's been a big part of it. I do want to talk briefly about Georgia, and just for those of you who are aware, prior to 2011, it was not impossible but difficult to enforce non-competes in Georgia. At that point, we didn't have a statute. All of the rules about what a non-compete could do or not do. The biggest one being that if there was any problem with the non-compete, the court couldn't modify it, or what we call blue pencil it, to make it more reasonable. It was all or nothing. And so here in Georgia, there were a lot of non-competes that would get struck down. Now, in California, for years and years and years, non-competes have been completely illegal by statute. And Georgia was sort of put in that boat, probably unfairly, I mean, because there were non-competes that, if they were drafted properly, could be enforced. But the Georgia General Assembly decided, as a matter of public policy, that non-competes should be enforceable. And so there was a ballot referendum, for those of you who lived here at the time and may remember, in 2010, when we all went to vote. There was a question about, basically, are puppies cute? It was a ballot referendum that was designed to get a yes vote, basically didn't tell the voters what they were voting on, and said something about Georgia being more competitive and allowing enforcement of certain agreements. And so, it passed overwhelmingly. The reason there had to be a referendum was that the Georgia Constitution actually said that non-competes were not permitted. And so the Constitution had to be amended. That's what required the referendum. And then after the yes vote on the referendum, the legislation went into effect here in Georgia that made it much easier for employers to enforce non-competes. Now, one of the big issues, and one of the things we'll talk about in relation to what the FTC is doing, was that the proponents of the bill in Georgia were suggesting, and I don't think the legislation ultimately did this, but their intent was that non-competes would only be permitted against certain categories of employees, not against every employee, and in particular, not against lower level or lower wage workers. In practice, that's really not how it's played out. There's been non-competes enforced in Georgia against backhoe operators, against hairdressers, against cake decorators. And so, while there may have been good intentions with respect to the Georgia statute probably has been interpreted more broadly than was originally intended, and non-competes are generally enforceable here. When the bill was being debated at the General Assembly, I had the opportunity to go down and testify, and I had done a bunch of reading. There were all of these studies out there that called into question whether the greater enforcement of non-competes was good as a matter of economic policy. Is it good for economic development in the state of Georgia, for example, to have greater enforcement of non-competes? And there were quite a few studies that suggested that was not the case. And I wasn't necessarily opposed to the legislation in Georgia because there were a lot of problems with the restrictive covenant law as it existed as the courts had developed it. But I was concerned about whether it was good policy to go as far as the statute intended to go. One of the examples is that in the mid-70s, there's this corridor, I think it's I-78 in Massachusetts, that had a similar number of tech companies to Silicon Valley. And from then until the early 2000s, Silicon Valley took off. And while Massachusetts certainly has a nice tech community, it's not anywhere near Silicon Valley. And the researchers concluded that it was because Massachusetts strictly enforced non-competes, and California, they were illegal. And the fact that they were illegal in California led to a much more entrepreneurial, innovative environment that led Silicon Valley to be what it is, and why Massachusetts tech community stagnated. Now, there's a lot of ways to call that into question. Kevin Levitas, who was the primary proponent of the bill here, was the one who was grilling me when I was testifying, and he said, "Well, where would you rather live, in the snow belt of Massachusetts or in sunny Silicon Valley?" Like, that was his explanation for why that difference occurred. There really is no way. There are a whole host of economists and academics who have tried to study this issue and figure out what really is the best policy. And there's so many factors. So you would think Georgia, for example, would be a great laboratory, right? We had very limited enforcement of non-competes up until 2011. And since then, we've had liberal enforcement of non-competes. You could look at the economic development, but there's so many, the impact on economic development. But there's so many other factors, including the fact that we were coming out of the Great Recession, and a whole host of other things that have occurred in Georgia, and you can't control for those other factors to determine whether it was good policy or not. But that's just a little background and sort of a little, it's helpful to understand sort of what's now going on at the national level. And so, after the Jimmy John's debacle, the Obama administration, there was a Treasury report that came out talking about the negative effects of non-competes on the economy. And ultimately what that led to was a call to action by the Obama administration. And I think what's important, and Neal was pointing this out to me this morning, the call to action by the Obama administration suggested recommended practices, but really focused it on state regulation, and gave the indication that this is really something that should be regulated by the states, not necessarily something that should be regulated by the federal government. And the recommendation was that states should ban non-competes for certain categories of workers, particularly lower wage earners. And then also to improve the transparency and fairness of non-competes, contemplating notice requirements and consideration beyond continued employment. So with notice requirements, for example, Massachusetts changed their law, I guess it was about 4 or 5 years ago, maybe a little bit longer. There were a bunch of changes, but one of the things was that employers had to provide employees with the proposed non-compete they were going to be required to sign at the time the offer was made, or certainly at some period of time prior to accepting employment, so that people were provided with notice. Because you'd be amazed, and I know that hopefully none of our clients in the room do this, but how many companies they hire somebody, and when the person shows up on the first day, fill out the paperwork, the HR paperwork, the health insurance, and oh, by the way, here's this non-compete that you need to sign. And now someone's sold their house in Chicago, in the suburbs of Chicago, moved their family down to Atlanta based on this great new job that they've gotten, and they find out on their first day they've got to sign a non-compete. There's really not much that person can do. They can't negotiate the terms of it. It's something that really is imposed on them. And so, some of these common sense rules that states started to implement. And again, what's interesting to me about the call to action is that the states responded. Carson is going to talk a little bit about this later, about some of the developments that have occurred at the state level since that time. And a lot of the legislation has focused on eliminating non-competes for lower wage workers and other categories of workers. And then also on notice requirements and sort of some of these common sense things that would rein in some of the abuse that was occurring. But in any event, that's not where it stopped. It didn't stop with the call to action. In 2018, the FTC got involved and announced that it planned to hold a series of public hearings on whether broad-based changes in the economy, evolving business practices, new technologies, or international developments might require adjustments to competition and consumer protection enforcement priorities and policy. Now, that actually did not mention non-competes, but ultimately the FTC did hold workshops starting in 2020 on non-competes, and there were a series of workshops, public hearings about the impact of non-competes. And that was really in January 2020 when the FTC began looking into the propriety of regulating non-competes. Now keep in mind, we have Obama and Biden up here, but this went on all through the Trump administration as well. And I think one of the things that's fascinating to me is there does appear to be bipartisan support, bipartisan sort of agreement on this issue. Neal's going to talk about the Workforce Mobility Act that has been reintroduced in Congress by a bipartisan group of senators, and that would largely codify what the FTC is trying to do by rulemaking. So this is not a blue or a red issue. This is an issue that seems to cross party lines. So now, in the Biden administration has made this certainly more of a priority. Under the Trump administration, like I said, things continue to occur. The FTC continued to look into this issue, but there wasn't a whole lot of activity. In President Biden's campaign materials, there was actually a section about the fact that Non-competes were were impeding employee mobility and suppressing employee wages, and was something that needed to be addressed. And so when he was elected in 2021, there was an executive order where he ordered the FTC to look into this issue more closely and consider rulemaking. I think at the time, most of us who practice in this area and follow these developments thought, well, that's an executive order that doesn't even, some executive orders in theory have the force of law. This was an executive order that, basically told the FTC, well, why don't you look into this? So we really didn't think it was going to go anywhere. But the FTC throughout 2021 held more workshops, and that's what led us to where we are today, which is where they've proposed this rule that would outlaw non-competes except in very limited circumstances on a nationwide basis. And Neal is going to talk more about what the rule actually says and what would it actually do. But I think one thing that's important to keep in mind is that even before revealing the proposed rule, this happened in quick succession, but on January 4th of this year, the FTC announced certain enforcement actions against a number of companies that it had engaged in under what it contends is its current mandate and its current legal authority. One involved a company called Prudential Security, and that's I believe a nationwide security company that had basically security guards who were making minimum wage or were hourly workers making at or near minimum wage. They had to sign non-competes that said they would not work in a competitive capacity providing security services within 100 miles of where they worked for Prudential for up to 2 years after they left. And if they violated it, there was a $100,000 penalty associated with violating that non-compete. Now, Prudential had actually sued a number of former employees who had gone to work as security guards within 100 miles. And even after certain courts had found their non-competes to be unenforceable, they continued to sue former employees. So the FTC got involved and basically brought an action. Now, as I understand it, the way it worked is that the FTC went to this company and said, look, we're going to sue you, and here's all the things we're going to allege and what we're going to win. And basically they entered into negotiations over the consequences to the company. And so the FTC basically ordered the company to cease enforcing, threatening to enforce or imposing non-competes on the relevant workers, that the company had to notify all affected employees that they're no longer bound by the non-compete restrictions, that the company was banned from communicating to any relevant employee or other employer that the employee is subject to a non-compete. They were required to nullify the non-competes that were already in place without penalizing the affected employees. They were actually required to provide a copy of the FTC's complaint and the order to current and future directors, officers, and employees of the company who were responsible for hiring and recruiting. And they were also required for 10 years to provide clear and conspicuous notice to any relevant employees that they may freely seek or accept a job without any company or person run their own business or compete with them at any time following their employment. So, the FTC, even before attempting to implement this rule, was already going after companies that were engaging in what they perceived as abusive non-competes. There were a couple of other cases. There was 2 companies involved in the manufacture of glass food and beverage containers, and they had 1-year non-competes that basically barred workers from working for any competing company anywhere in the United States. And they had thousands of employees who were required to sign those agreements, and the FTC went after them as well and required them to enter into a similar consent order. So, the FTC's enforcement action.
Excuse me. Workers are beginning stiff, but not anymore.
Well, I'm sorry about that. I was going to introduce that by saying, doing this for 30 years, I never thought I would hear non-competes referenced in a President's State of the Union address, but that's exactly what happened the other day.
For too long, workers have been getting stiffed, but not anymore. We're beginning to restore the dignity of work. For example, I should have known this, but I didn't until 2 years ago. 30 million workers have to sign non-compete agreements for the jobs they take. 30 million. So a cashier at a burger place can't walk across town and take the same job at another burger place and make a few bucks more. It just changed. But they just changed it because we exposed it. That was part of the deal, guys. Look it up. But not anymore. We're banning those agreements so companies have to compete for workers and pay them what they're worth.
So, no matter what side of the aisle you sit on or what your politics are, to me, it shows sort of where this issue has come since 2014, that it's being addressed by the President of the United States in a State of the Union address. And I think the issue is, and Neal's going to talk about it, what the rule actually does, but from our perspective, the concern about this proposed rule is that it's across the board. Now, that's the way it's been in California for as long as I can remember, and companies there have done just fine. But there are certainly legitimate reasons to have non-competes for certain employees. Again, those who have certain customer relationships, employee relationships, access to confidential information and trade secrets, and the FTC is not making any exception for that. And that's something from a policy perspective that is of concern, particularly for those of you at your companies who use non-competes for higher level executives, for the folks who can hurt you competitively if they were to leave. Yes?
And often non-disclosure agreements are close to or intertwined. Have they spoken to that issue at all?
Somewhat, and Neal's going to talk more about this. The rule talks about basically a de facto non-compete, and to the extent that a confidentiality or non-disclosure provision would essentially prohibit somebody from going to work for a competitor, the FTC may take the view that that is essentially a non-compete. Now, a lot of this is inconsistent with, the trade secret protection has become a huge issue. It was all governed by state law up until 2015, when the Federal Defend Trade Secrets Act was passed by Congress, again on a bipartisan basis, because there was the concern about the theft of trade secrets and the use and disclosure of trade secrets. And so there really is, in my view, a tension on that issue, and we can talk more about that when we get to talking about what you should do now. So I'll turn it over to Neal. Yeah, Dave, I'm sorry.
Quick question. Is it around deployment agreements? How about purchase agreements, asset purchase agreements?
I'll let Neal talk about that. There is a reference to that, and it's even more concerning in my opinion.
In issuing this rule, the FTC made the determination that it's an unfair method of competition for employers to enter into non-compete agreements, non-compete clauses with workers, to maintain non-compete clauses with workers, or to represent to the worker that the worker is subject to a non-compete clause where the employer has no good faith basis to believe that the worker is subject to an enforceable non-compete. So that's kind of where this idea that there's a broad-based ban that the FTC is saying non-competes are an unfair method of competition and they're no longer allowed. So you might be wondering, okay, who's a worker? How broad a classification is that? How far does that reach? And the worker is defined very broadly in the proposed rule. And just for context, and we'll talk about this a bit more, it is a proposed rule right now. So the FTC issues a proposed rule. There's a opportunity for the public to comment on the rule. That's kind of the way agency regulation and rulemaking works is agency puts out a proposed rule, public gets an opportunity to comment, and then the agency has the opportunity to review the comments, review the feedback, and either make changes and issue a new proposed rule, finalize the revised proposed rule, or issue the rule in its current form, or not issue a rule at all. So we're in that stage where there's a proposed rule that we're during that comment period, which we'll talk a little bit more about. So the definition of worker, it's extremely broad. Employees includes employees, independent contractors, externs, interns, volunteers, apprentices, sole proprietor. Does not include franchisees, but does include anybody, any worker that is doing work for a franchisee or franchisor. So clearly designed to kind of capture anything and everything, anybody that's part of the labor workforce. So kind of just going at a high level to summarize the main elements of the rule. I mean, it is truly, Ben alluded to this, there's been some questions about it. It's a prohibition on the use of non-competes and employment agreements at all levels for all workers. It's a little bit ironic that at the State of the Union, President Biden is talking about the Burger King cashier, because not only does this rule apply to the Burger King cashier, but it would apply to the CEO of Burger King or the CEO of Coca-Cola. So from the top to the bottom down, if someone is an employee in the workforce, this rule would be a complete ban on the use of a non-compete with that person. Ben briefly alluded to de facto non-compete clauses, which I'm going to talk about a little bit further in an upcoming slide. That's what that does is broadening non-compete beyond what we kind of typically think of as a non-compete. Non-compete's usually thought of just as a prohibition on someone accepting employment with a competitor after the end of their employment or opening a competing business. The de facto non-compete indicates that the FTC is going to consider other provisions that have the effect of restricting that same conduct, of prohibiting somebody, if it has the effect of somebody taking a job or opening a competing business, that's going to be treated and viewed like a non-compete in the FTC's eyes. Under the rule, employers have to notify their workers of the prohibition and to rescind any existing non-competes in effect. We'll talk about what that it would look like under the proposed rule, just so everyone kind of has some context of what the future might hold or might not hold. And the rule will supersede state law and non-competes. So if the rule goes into effect and a court holds that it's valid, we'll talk about potential court challenges to the rule. It's going to have the force of federal law that would preempt state law. Now, the federal regulation, it does not necessarily address all other covenants, so it appears to us that we could be in the quandary where federal law is governing the enforceability of non-competes, but then Georgia law is governing the enforceability of customer non-solicitations, employee non-recruitment covenants. So turning back to what's a de facto non-compete. A de facto non-compete is a provision that has the effect of prohibiting the worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment with the employer. They call this the functional test for determining what's a non-compete. The FTC, in its both in the proposed rule and in the notice of rulemaking and comment, kind of spells out what are some examples of de facto non-competes. One of them we heard about already is a non-disclosure agreement between an employer and a worker that is written so broadly that it effectively precludes the worker from working in the same field. So, sometimes non-disclosure covenants are drafted narrowly where they truly only cover confidential information and trade secrets of the employer. And sometimes non-disclosure covenants are drafted too broadly, where they might cover, someone, let's say someone works for a company for, it's their first job out of college, they work there for 15 years. So everything they know, all their knowledge, all their industry experience really is, information based on information that they've learned from that employer. In that scenario, I can envision a non-disclosure covenant that goes too far. If that non-disclosure covenant is going to kind of capture information that really is just, this is what you know from being in this industry, the FTC is going to look at a non-disclosure covenant like that and consider it to be overbroad and to be a de facto non-compete. But the FTC does make clear in its comments that reasonable non-disclosure clauses and also customer non-solicitation covenants and employee non-recruitment covenants, those are not necessarily prohibited by this rule, assuming, again, that they're reasonable in the eyes of the FTC. Another type of de facto non-compete, this is kind of typically referred to as a training repayment provision. So when you have a contractual provision that provides that the employee, if they leave, has to repay training costs, that where the required payment is not reasonably related to the cost the employer incurred for training the worker. One of my colleagues, Chuck Van Horn, he got a call from a contact recently where this lady's employment contract provides that if she leaves, she has to repay 15% of her salary as a repayment for the investment in the training and the experience, that really the training that she supposedly got from the employer. That's the exact kind of provision that the FTC is going to look at and say, this is a provision that's a de facto non-compete, because someone is going to see that provision in their contract and they're going to just conclude, okay, I may not be able to go to another employer or another competitor, because if I leave, I have to repay this money that I don't have, and that has the effect of keeping me from leaving and finding a different job. So the FTC is not going to like that, and it's going to treat that as a de facto non-compete. Other examples, disproportionately high liquidated damages provisions for violation of other restrictive covenants. We see this in the accounting world sometimes when we look at an agreement, a restrictive covenant agreement for an accountant that's contemplating leaving. There may not be a true non-compete, but there may be a provision that says if a client follows you to your new employer, you're obligated to pay 1.25 times the annual revenue from that client in the trailing 12 months before that person left. So it's not a restriction on either competing or accepting that business, but it's effectively a liquidated damages provision that is going to give someone a serious pause about making the transition. That's another kind of provision that the FTC is going to surely treat as a de facto non-compete. And these are just examples. There's a handful of examples that the FTC has provided, but it's conceivable that there's other provisions that, if this rule takes effect, that the FTC would consider to be de facto non-competes. So what does the rescission requirement under the FTC's proposed rule look like? Employers will have to, under the rule, rescind their non-competes by the date of compliance, which we'll talk about what that time frame would look like in a little bit. Employers must notify employees that the non-compete's no longer in effect. This can't be sort of the mass communication to the entire company. It's got to be individualized. It's got to be in writing or by digital means, by email. It can't be sort of an over the phone like, hey, I want to let you know that you're, good news. We can't enforce non-competes anymore. It's got to be a formal, documented rescission. It has to be given to current and former employees. So, someone that left 16 months ago, but they're still in the middle of a 24-month non-compete, the company has the would have the obligation under the rule to provide this notice, the rescission notice, to the best available address for a former employee. I've included the sample notice that the FTC's rule includes. They've set out a sample notice for employers to use, and it's pretty mind-boggling to kind of see this in real life. I mean, it would be a letter that says, dear employee, new rule enforced by the FTC makes your non-compete unlawful. You can accept a job somewhere else. You can start your own business. You can compete with us. Hard to fathom. Hard to fathom. These letters going out to employees, but that's clearly what the FTC is contemplating. Something looking like this or something like this, if this rule goes into effect. Now back to the question that I think Dave asked about, exceptions to the rule. Does this rule apply to all non-competes? And there are some exceptions, but it's by and large it's very limited. One is a exception for covenants entered into in connection with the sale of a business. Now, the caveat to that is only owners that sell a 25% interest or more of a business are kind of fit within this exception. So, if if there's a sale of a $100 million business and there is a 40% owner, another 40% owner, and a 10% owner, and then a handful of employees that maybe have fractional interests or very small interests, but they're maybe still getting nice consideration in this deal. The only employees, the only owners, the only sellers that can be subject to non-competes as part of that sale would be the two 40% owners, meaning that there can be no restriction on either that 10% owner or the smaller fractional owners going and competing after that sale, which that's something which, there's a lot of times, probably many people in the room might have businesses where there are 4 or 5 owners and maybe one person owns 51% and 4 people own 10% and someone else owns the other 9%. The reality that the buyer doesn't have the ability to prevent these other owners from competing following a sale where there's significant consideration being paid, including to those owners. That's something that kind of when we look at this, we don't necessarily think that that's well thought out by the FTC. There's some issues there. Another area of where there's an exception is there's certain industries where to which the Section 5 of the FTC of the Federal Trade Commission Act, which that's the statute that gives the FTC the power to look at and address unfair methods of competition. There are some industries that are outside the scope of what the FTC can do. Banks, federal credit unions, savings and loan institutions, common carriers, air carriers, and foreign air carriers, persons in business subject to the Packers and Stockyards Act. I had to look up what that is, and that's the businesses that market and sell meat and livestock and poultry. So, there are some gaps in what the FTC is doing, just created inherent to the fact that it doesn't have the authority to regulate certain industries. Raises interesting questions. Banks these days don't just do traditional banking; they do lots and lots of other ancillary services. And if a kind of ancillary business, if a insurance brokerage business is sort of under the kind of bank parent umbrella, are the employees of that that division or that subsidiary, are they under? Can the FTC kind of regulate those folks? That's something that kind of remains to be figured out. Kind of where these lines will be drawn in terms of where does the FTC's authority reach? Another interesting area of exception is nonprofit businesses. The FTC's authority does not reach nonprofits. So, many healthcare systems, hospitals are technically organized as nonprofits. In this day and age, kind of may not necessarily look like them, may not necessarily look like nonprofits, but they are. So there's that's a significant area where we see the regular and heavy use of non-competes, not necessarily kind of non-compete abuses, since I think physicians are typically kind of looked at as well-educated, able to negotiate, in a position when they're signing their employment agreements to make decisions about, do I want to bind myself to a non-compete? But there's certainly a heavy presence in this day and age of use of non-competes in those types of organizations, where it'll be interesting to watch how this plays out and to kind of really assess, okay, where is the line on what the FTC can and can't do in that space. Other question marks in this area: if a nonprofit company is has a for-profit subsidiary, or it's partnering with a for-profit company in a for-profit joint venture, does this rule apply or does it not apply? So that's kind of a breakdown of the rule. I'm going to kind of quickly run through current status of the rule. How likely is it to take effect? Rule's been announced. I mentioned we're in the notice and comment period. The notice and comment period runs 60 days. There's been a request for an extension by a long list of industry organizations. FTC may finalize the rule or issue a revised proposed rule. There's a government office that, because of the economic impact that even the FTC acknowledges this is going to have, would take a look at the rule. Final rule gets published. Congress actually has the power to effectively veto the rule. If Congress vetoes the rule and then the president approves that veto, the rule wouldn't go in effect. If that does not happen and the rule goes into effect, then employers have the 180-day period to comply with the rule following its publication. Going to quickly talk about potential challenges. There's a big question of, can the FTC do this? And I've got a quote up here from the U.S. Chamber of Commerce, which aggressively says no. They say the day that the rule became big news, today's actions by the FTC to outright ban non-compete clauses in all employer contracts is blatantly unlawful. There's a few different kind of constitutional theories for why the FTC can't do this. We're running a little short of time, so I'm going to kind of spare y'all the details of kind of why you can. I'm happy to chat about that in more detail. At a high level, what I'll say is the current Supreme Court, the conservative makeup of the Supreme Court, is fairly hostile to agencies doing what in the court's eyes is really the duty of the legislative bodies of Congress. So when there's been a reining in of agencies that the Supreme Court views as kind of going beyond their agency power, and there's fairly compelling arguments that in this situation the FTC is going beyond the power that Congress has granted it. Briefly talk about the Workforce Mobility Act of 2023. As Ben mentioned, this is a federal legislation, bipartisan legislation, introduced in Congress shortly after the proposed rule was promulgated by the FTC. This particular law fairly closely mirrors what the FTC is trying to do. It would be nearly a complete ban with exceptions for sale of business, for senior execs that enter into severance agreements as part of the sale of a business, and for covenants entered into as part of kind of partnership breakups. So it's maybe a little bit little bit narrower, but still very broad in that it would ban all employee non-competes. There have been other, in past federal legislative sessions, there have been other proposed legislation that takes a more narrow approach, like Senator Rubio has introduced and reintroduced legislation that would ban non-competes for anyone that is non-exempt under the FLSA, under the Fair Labor Standards Act. That's obviously more targeted towards the issue of low-wage workers. And with that, as Ben mentioned, there's been a flurry of activity on the state level, both before and after the FTC's rule. I'm going to turn it over to Carson to talk about that.
Hi, I'll be fairly brief and respectful of your time. But yeah, as Ben mentioned, there's been kind of a general movement across states to narrowly tailor non-competes and make them more targeted towards lower wage or towards protecting lower wage employees. The goal seems to be reducing the capacity of abuse for non-competes while keeping them in effect. And so the three big things that we're seeing in other states are things like setting a wage threshold, and that can be either a certain percentage of the your salary is a certain percentage of the federal poverty level, or you're an hourly worker, or you make a certain amount per week, or you make a certain amount per year. It could be any of those types of wage markers that determine whether you are eligible for your non-compete. Same with notice requirements, which I'm skipping down to number 3 here. Employers are required to provide advance notice of non-compete provisions to new hires. They can be required to provide post-employment notification that, hey, don't forget you have this non-compete. Things like that. That is in 8-ish states, not in Georgia. And then in that middle one there's also a few states that have their enforceability of the non-compete is triggered by cause of termination. So if you're involuntarily terminated in New York, your non-compete is unenforceable. And there's a handful of states where how you've left your employment has an effect on whether your non-compete is enforceable against you. Again, not in Georgia, but other states, about a handful of them.
Thanks, Carson. So I'm going to talk about, what do we do now? I guess the one thing I want to mention is that it really is interesting to see how this is playing out. So Neal and I are involved in an organization, the AIPLA, the American Intellectual Property Law Association. So there's lawyers from all over the country. And in talking to our colleagues in California, for example, there's a lot of companies out there and a lot of organizations that are rooting for this rule. They're in favor of it because non-competes are illegal in California. And so they view it as, the companies out there view it as leveling the playing field, because one of the issues they have is that they can't have non-competes, but their competitors that are based in Illinois or in Atlanta or in wherever it may be can. And so there's sort of this playing field that is not level for California companies in some regards. And as Neal was mentioning it, this carve out for nonprofits could create something similar. So if you had, for example, a nonprofit hospital system right next to a for-profit hospital system, and this rule goes into effect, the nonprofit hospital system can still have non-competes, where the folks down the street at the for-profit hospital won't be able to do that. And that'll create sort of an unlevel playing field even within certain states and within certain communities. It is always funny to me. We as lawyers, our ethics rules prohibit us from having non-competes, and the rationale is that the public should have the absolute right to choose their lawyer. What's funny to me is that in most states, including Georgia, non-competes are perfectly legal for doctors. So we have the absolute right to choose our lawyer, but not necessarily the right to choose our doctor. But that's something where we've self-regulated as lawyers. The doctors have chosen not to do that, and that's their prerogative, I guess. What should you be doing? I mean, first of all, look at your agreements to make sure they're narrowly tailored. As Carson mentioned, as I mentioned briefly, there has been a ton of activity in other states on this issue. And so if you have employees outside of the state of Georgia, it's really important to look at the law in that particular states where you have those folks. And a lot of times clients or companies will say, well, we'll just put a provision in our agreement that says that Georgia law applies, or we'll choose the law of Delaware because non-competes are enforceable there. The problem is that some states now have statutes that say that a choice of law provision like that is unenforceable. So if you have an employee in North Carolina, for example, and they have an agreement that says it's governed by Georgia law, there's a statute in North Carolina that says that's not valid. Not surprisingly, there's something very similar in California, and California has gone one step further, which is that California says that so another thing that companies will do is say, okay, not only does Georgia law apply, but if there's ever a dispute and we need to sue you, we can sue you in Georgia. That's called a forum selection provision. It says that any litigation, any dispute will be brought in the particular state, whether it's Georgia or wherever the company is based. The problem with that is, like in California, that's illegal. You cannot have that in an employment with employees. You can't have that in an employment contract. So the employee, if you're an Atlanta-based company and you've got employees in California, you can't do an end run around the California law by including a Georgia law provision or a Georgia forum selection provision. So even without the FTC rule, you need to be thinking about your restrictive covenant agreements and how they work if you have employees in other states. I think a very simple and sort of common sense approach is to not use non-competes with lower wage workers. I will say I've got a client in the biotech industry, and they've got folks that work in their labs that are minimum wage or slightly above minimum wage workers who do have access to information that is truly a trade secret because they see the process that the product goes through in the manufacturing process. And so I wouldn't say that as a blanket rule, anybody that's a lower wage worker shouldn't be subject to a non-compete. But even in that context, a non-disclosure provision, a confidentiality provision, other covenants can often protect the company and provide what it needs. It is worth taking a look at your confidentiality provisions, your non-disclosure provisions, to see if they are somehow creating a de facto non-compete along the lines of what the FTC is concerned about. And if they are, to start thinking about perhaps modifying those restrictions so that if the rule goes into effect, your agreements don't run afoul of that de facto, the prohibition on de facto non-competes. The other thing is that one of the rationales for non-competes, as I've mentioned a few times, is protection of trade secrets and confidential information. And the FTC and a lot of the proponents of this rule say, well, we have a trade secrets statute and it's illegal to steal and use trade secrets, so why do you need a non-compete? The folks on the other side will say, well, a non-compete can help us avoid someone using or disclosing trade secrets in a competitive way in the first instance because they can't even go work for a competitor. So I don't need to worry about my trade secrets being disclosed to a competitor. But regardless of how that ultimately shakes out, one of the key things you can do now is be looking at your trade secret protection, your confidential information, how is it kept, how is it stored, who has access to it, making sure that the information that gives your business a competitive advantage is protected regardless of whether you can enforce a non-compete. And then, the other is just to be cognizant of what this looming rule, the impact this looming rule could have. I know Dave asked the question, and a lot of folks are shaking their heads about the sale of business part of this. In almost every state where non-competes are disfavored, including California, non-competes are enforceable against the seller of a business, and it's hard to understand the rationale for why that would be prohibited. Now, as Neal pointed out, if you are selling more than 25%, then the rule would not apply. But the example I heard from a friend of mine who's paid real close attention to this as well is you could have a company, right, Dave, where someone sells 50% of the company for $500,000 and they can be subject to a non-compete. You could have someone who could sell 10 or 15% of a company for $50 million and they cannot. It makes no sense sort of to draw that line at that percentage. And so that's, those are the things to start thinking about, particularly if your company is involved in or is planning to be involved in any M&A activity or acquisitions, and how this rule may impact the restrictions you can obtain from the sellers of the business. And so I think with that, that's what we've got. If anybody has any questions, I think we've got a few minutes left and are happy to answer them. Yeah, Curtis.
How about notice, Ben? If you have an agreement with a employee to give you notice and tell you where they're going, does that necessarily violate these proposed situations that the FTC is talking about? Because I'd like to know if somebody's going to go off and compete and join a competitor of mine.
Yeah, that's a great question, and I'll answer it by saying that I don't think the rule doesn't address that directly. I would think that the FTC's position would be, well, if you can't stop them from going to a competitor, why do you need to know, right? So, well, but you can't get an injunction to stop them from going unless, if the non-compete is unenforceable, right? But the other thing that brings up is a great question, which is notice provisions. Notice provisions have become more and more common. I'm seeing them more and more. We see them in the insurance industry all the time, that if you're going to leave, you've got to give 30, 60, 90, I'm looking at one right now that's a 1-year notice in the financial services industry, that you have to give that amount of notice. In Georgia, for example, the courts have found that's not a non-compete, that's not a restrictive covenant, that you can require an employee to give you 60 or 90 days or even up to a year's notice before they leave your employment. Now, that can't prevent somebody from actually then leaving and going to not giving the notice and leaving and going to a competitor, because involuntary servitude went out with the 14th Amendment. You can't require someone to continue to work for you during that 60, 90 days, that 1-year period. And so, but if they violate it, then you may have a damages claim for any damage that's caused to you as the employer for that person not giving you the notice that's required. I just don't think you'd be able to enjoin them from going to work for a competitor during that period of time.
And I would think it's fairly probable that if there were a 180-day or a 1-year notice provision, that the FTC is going to look at that as under this functional test for what's a de facto non-compete. That would have, even if there's not a non-compete and there's just a 1-year notice provision before you leave, that's going to have the effect of deterring someone from going to a competitor, and FTC might conclude that that's an unfair method of competition under its rule.
Yeah, I know Neal mentioned it. I do think at the end of the day, there will definitely be some rulemaking around and potentially legislation around lower wage workers. I think if the FTC does this Supreme Court is very likely to strike it down. But as Neal pointed out, there seems to be some momentum in Congress to do this anyway. And if that were to happen, I think the ability to challenge a federal statute is going to be much more limited than the ability to challenge a rule by the FTC. Yeah, Dante.
One of the things that I think about, that it's sort of the undertone of this, which is, do you anticipate regulatory bodies exploring, I guess, alternative means of trying to manage protecting legitimate interests versus retaliatory action? Now think about the abuse of the laws as they, and prompted this conversation and even proposal, I think about the very raw sense of an employer blurring the lines between, I'm pissed off that you're leaving, and you may have had an impact in my business. I'm not necessarily threatened by exposure of my intellectual property or your pursuit of my existing prospects or clients, but I simply want to make it difficult for you, right? Do you have any other examination around actions that an employer may take that's retaliatory?
Yeah, and I think that, you know, that's really what drives a lot of this, right? Is that there, as I said a few times, there are legitimate business interests that a non-compete can, in some ways, protect, right? Trade secrets, confidential information. The goal should be to avoid, and it's always been, and in every state you have to demonstrate a legitimate business interest to enforce a non-compete. It can't be just to stop someone from competing, right, on its face. And so I do think that that is, as part of what's going on here, is to, you know, stop sort of the retaliation or the vindictiveness that sometimes occurs when someone leaves when they're really not a competitive threat. Dante, you know, the fact that you asked a question that, you know, reminded me that many years ago we did one of these lunch and learns on, you know, how do you retain people so that you don't have to worry about enforcing a non-compete? And that's Dante. You know, for those who don't know, you know, Dante's business is, you know, is helping companies with company culture, and that doesn't do it justice because it's way more than that. But you know, if you have a really positive working environment and you pay people fairly, you're much more likely to retain people, right? And you have to worry less about your non-competes. Now, in today's world, we all know that no matter how good an employer you are, people are going to move, and so that's not entirely the solution. But it's certainly something in the what to do now category is reevaluate your company culture, reevaluate your compensation structure, and make sure that you're treating people well and paying people well. They're much less likely to be looking for other opportunities, particularly in a competitive manner. So I think we're just about out of time. I really appreciate everybody coming, and I want to thank Neal and Carson in particular. Carson did all the work to put this together, so we greatly appreciate her input. Thanks all.